All right, we now cross to the Johannesburg High Court, wherein the case of Ace Magashule versus ANC is now in progress. Let's go there now.
He cited in these proceedings in his personal capacity and in his official capacity as the president of the ANC. The second respondent is Ms. Yasmin Jesse Duarte, who is the Deputy Secretary General of the ANC. And the third respondent is the ANC. The relief that is being sought by the applicant is declaratory in nature, and the applicant seeks in substance the following relief. Firstly, he seeks an order declaring the ANC's step-aside rule or regime and or Rule 25.70 of the Constitution of the ANC to be unlawful, unconstitutional, invalid, and null and or void ab initio. He also seeks an order declaring the suspension letter issued by the second respondent on the 5th of May to be unlawful, unconstitutional, invalid, null and void ab initio. Thirdly, he seeks an order declaring the suspension of the first respondent to be valid and effective until lawfully nullified. And then he seeks an order declaring that the instruction announced by the respondents that he apologized for issuing the suspension letter to the first respondent to be unlawful and unenforceable. The background facts that underpin the dispute are complex, but we'll simply capture the main features thereof. The 54th National Conference of the ANC, which was held at Nasrec in December 2017, dealt with the matter of the ANC's credibility and integrity in some detail. And it appears that it was a matter that weighed heavily with delegates. Deep concern was raised about the impact of corruption on the affairs of the ANC, its role and sustainability as a political party, and the moral high ground it sought to hold. Arising out of this, there was a general consensus that it was time for more decisive action to eradicate the scourge of corruption. And that conference passed 4 resolutions in essence that dealt with the ANC's attempts to deal with corruption. One, it demanded August 2020, the NEC decided that, and we quote, pursuant to the resolution that those accused of corruption and other serious crimes against the people, including those charged in courts, may be expected to step down from their positions or responsibilities. It then goes on to indicate that the national officials of the ANC were requested to prepare an audit list of cases of such people. At the further meeting of the NEC held between the 28th to the 30th of August, the NEC took steps towards the implementation of the National Conference resolutions. It declared, quote, a turning point, close quote, in the fight against corruption. And in doing so, it distinguished between the following categories of members for the purposes of implementing the resolutions. And these were 3 categories. A, those who were formally charged with corruption or other serious crimes. They must immediately step aside from all leadership positions in the ANC. And if they do not step aside, they must be instructed to do so, read the resolution. Secondly, those who were not formally charged, but who have been reported to be involved in corruption and other serious criminal practices. They must appear before the ANC's Integrity Commission to explain themselves. Those who do not give an acceptable explanation may be suspended. And the third category, those who've been convicted of corruption or other serious crimes. They must resign from leadership positions and face disciplinary action in line with the ANC's constitution. The NEC then mandated the national officials of the organization to develop guidelines and procedures for the implementation of this resolution. In about November 2020, the National Prosecuting Authority charged Mr. Magashule with several criminal offences. Following his indictment, Mr. Magashule appeared before the Integrity Commission on the 12th of December 2020. In February 2021, at a further meeting of the NEC adopted the guidelines developed by a task team led by the Treasurer General of the ANC. And the guidelines distinguished principally between A, members who have been indicted on charges of corruption or other serious crimes, and B, members who were accused of corruption or other serious crimes, but who had not been indicted. And the guidelines then went on to provide how these two different categories of members would be dealt with. At a further meeting of the NEC held between the 26th and the 29th of March 2021, the NEC dealt with the implementation of the resolutions and the guidelines, and it resolved as follows, and we quote, "All members who have been charged with corruption or other serious crimes must step aside within 30 days, failing which they should be suspended in terms of Rule 25.70 of the ANC Constitution." Thereafter, and on the 3rd of May 2021, the Deputy Secretary General of the ANC prepared the letter of suspension of Mr. Magashule. On the same date, Mr. Magashule wrote a letter of suspension to Ramaphosa, addressed to him in his capacity as President of the ANC. Both letters were delivered to their respective recipients on the 5th of May 2021, and on the following day, Mr. Magashule delivered his appeal/review letter to the Deputy Secretary General, pointing out 12 legal defects in respect of his suspension and purporting to exercise the right to seek a review of the suspension decision for consideration by the NEC. On the 10th of May, and following a meeting of the NEC, Mr. Ramaphosa read out a statement arising out of the NEC meeting, and it contained, amongst other things, the following. It confirmed Mr. Magashule's suspension. It appointed the Deputy Secretary General to perform the tasks of the Secretary General. It indicated further that the letter of suspension written to Mr. Ramaphosa by Mr. Magashule was written without any authority or mandate from any ANC structure, and agreed that Mr. Magashule's conduct was, quote, completely unacceptable and a flagrant violation of the rules, norms, and values of the ANC, close quote. It further instructed the officials to advise Mr. Magashule to withdraw the letter of suspension, purporting to suspend Mr. Ramaphosa, and to apologize for writing it. On the 12th of May, the Deputy Secretary General addressed a letter to Mr. Magashule, calling upon him to publicly withdraw Mr. Ramaphosa's suspension letter and to apologize. And on the 12th of May, Mr. Magashule wrote to the Deputy Secretary General stating that his rights had been violated, that he would not apologize, and that he was seeking urgent redress in the courts. The present application was launched on the basis of urgency on the 14th of May 2021. That as far as the background to the dispute is concerned. Before dealing with the main features of the merits of the dispute, we deal with, in the main, judgment with an application to strike out. This application was brought by Mr. Magashule, seeking to strike out Mr. Ramaphosa's answering affidavit in its entirety. The application to strike out also dealt with certain documents which Mr. Magashule contended were irrelevant and should not have been annexed, and further additional documents which Mr. Magashule contended were duplicated documents and should be struck out. For the reasons given in the main judgment, we dismissed the application to strike out, and we dealt with the question of the duplicated documents only insofar as it relates to costs. There was also an application for condonation brought by Mr. Ramaphosa in respect of the late filing of his answering affidavit. In particular, he sought condonation for the period the 25th to the 27th of May, and having been satisfied that a proper case was made out for condonation, we granted condonation in respect of the late filing of his answering affidavit. We also, for the reasons that will appear in the main judgment, concluded that there was no condonation application necessary in respect of the period 20th of May to the 25th of May, as contended for by Mr. Magashule. Proceeding then to deal with the issues on the merits, there are 5 issues that we traverse in the judgment. The first is the question of whether Rule 25.70 is unconstitutional in relation to the Constitution of the ANC as well as the Constitution of South Africa. We first deal with the contention that Rule 25.70 is in conflict with the ANC's own constitution. The thrust of Mr. Magashule's argument is that Rule 25.70, which is located in the chapter of the ANC Constitution dealing with managing organizational discipline, is inconsistent with the other provisions of the chapter. In particular, he argues that Appendix 3 of the ANC Constitution applies generally to all disciplinary processes, including a decision to suspend, and not only to disciplinary proceedings. Mr. Magashule submits that it must therefore apply to a decision taken in terms of Rule 25.70, and to the extent that it does not, it is in conflict with the Constitution of the ANC. What is clear is that Appendix 3 is only concerned with disciplinary proceedings and deals exclusively with them from their commencement to their finalization, including covering matters such as the charge sheet, the plea, the presentation of evidence, the verdict, and the post-verdict process. However, there is nothing in Appendix 3 that suggests that it is applicable to a decision taken outside of the context of disciplinary proceedings, and in particular, there is no reference to a decision to suspend taken either in terms of Rule 25.70 or any other rule. Mr. Magashule's insistence that Appendix 3 applies to decisions taken in terms of Rule 25.70 is therefore without foundation. Accordingly, the contention that Rule 25.70 stands to be struck down because it is in conflict with the ANC Constitution, in particular Rule 25, as read with Appendix 3, stands to be dismissed. That is the first line of attack. The second is the exclusion of the audi alteram principle in Rule 25.70. Mr. Magashule says that Rule 25.70 is susceptible to attack because it does not provide for the application of the rules of natural justice, including audi, in its formulation, and therefore falls foul of the Constitution of South Africa. As we understood his argument, it was the contention that textually Rule 25.70 is fatally flawed. When one has regard to Rule 25.70, then it is our conclusion that it cannot be struck down as unconstitutional on the basis that it is silent on the principles of natural justice. The answer to Mr. Magashule's assertion is simply that where, on the one hand, the decision to suspend taken in terms of Rule 25.70 is punitive in nature, the rule may well require the applicability of the principles of natural justice. On the other hand, a precautionary suspension does not attract the principles of natural justice and cannot be rendered open to attack when those principles are not applied. This is as a matter of principle, and this is the state of our law as expounded by the Constitutional Court in the matter of Long versus South African Breweries, and we deal fully in the judgment with the question of whether the suspension of Mr. Magashule ultimately was punitive or precautionary in nature, as that would trigger or not the application of the principles of natural justice. So accordingly, on this aspect, it cannot be said that Rule 25.70 is unconstitutional, as it is certainly open to being interpreted to include and incorporate the principles of natural justice, and the challenge to the constitutionality of Rule 25.70 must accordingly fail. The next feature of the challenge to his suspension by Mr. Magashule is the contention that Rule 25.70 is in conflict with the Constitution of South Africa. And in advancing this contention, Mr. Magashule does so on a number of bases. Firstly, he contends that it violates or limits his right to participate in political activity as provided for in Section 19 of the Constitution. Section 19 of the Constitution guarantees to everyone the right to join a political party and to participate in the political activities of such a party. Now, on this score, clearly the ANC is entitled to manage its membership to ensure that it admits only those that subscribe to what it stands for. Having done that, it is also, as the Constitutional Court reminded us in the matter of Ramaphosa versus Magashule, entitled to internally regulate that membership and its participation in accordance with the broad objectives of the organization. That is, in fact, the essence of what its associational rights and the recognition of its autonomy requires, and accords in all respects with Ramaphosa when it says that these are matters internal to political parties and that they are best placed to regulate them. The ANC Constitution provides in the fullest manner for both membership and participation of its members in the affairs and activities of the ANC, as is evidenced by the contents of Rule 4 and Rule 5 of the ANC Constitution. The language of both Rule 4 and Rule 5 do not constitute any limitation on the right of members to participate. The scope of the right in Section 19 of the Constitution does not create a constitutional bar to the suspension and or expulsion of a member. The general tenor and terms of the contract between the ANC and its members clearly contemplated that the ANC would give effect to and regulate how membership was to be exercised. To suggest that every attempt to regulate and give effect to how participation is to be effected would constitute a violation or limitation of Section 19 would not do justice to Ramaphosa, which reminds us again that these are matters best left to the agreement between the parties and its members, provided, of course, it passes the scrutiny of the Constitution. Such an approach would also make unacceptable inroads into the associational rights of the ANC and its members, which include Mr. Magashule, Mr. Ramaphosa, Ms. Duarte, and many thousands of others. In doing so, they reflect what suits the structure and the functioning of their organization, and what is best suited to the character of their organization and the values they have collectively committed themselves to. In this regard, the right of an organization to discipline, suspend, or expel its members in defined circumstances does not stand in competition to the right to participate in accordance with its own autonomy and the associational rights it and all its members enjoy. Accordingly, it is not open to Mr. Magashule to seek to challenge the validity and the constitutionality of Rule 25.70 on the basis that it violates his Section 19 rights. In addition to his reliance on Section 19 of the Constitution, Mr. Magashule also relied on the general presumption of innocence. And he says that Rule 70 applies to persons who are charged and not convicted, and that accordingly it violates the presumption of innocence as it seeks to visit a sanction on someone who is entitled to the benefit of the presumption of innocence. For the reasons that we give, this right regulates the conduct of criminal proceedings and its operation is confined to those proceedings. The authors Curry and Duval remind us and make the point that, quote, the presumption of innocence is a specified constitutional right that arises only in the context of an accused's right to a fair trial. Rule 25.70 does not relate in any manner whatsoever to a trial, and therefore the attempt to apply it in the context of Rule 2570 is misplaced and not sustainable. The other two challenges raised by Mr. Magashule in relation to the violation of his constitutional rights are challenges located in Section 9 and Section 10 of the Bill of Rights. Mr. Magashule contends that his suspension results in the violation of his rights to equality and human dignity, located in Section 9 and 10 of the Bill of Rights. While it may well be argued that at the level of principle, an unlawful suspension may have the potential to impact on the dignity of an individual, if the suspension accords with the ANC's constitution and the jurisdictional requirements set out therein, then it can hardly be contended that it stands to be set aside because its effect is to infringe upon or impair the dignity of Mr. Magashule. If this was the case, invoking the right to dignity would stand as a bar to the giving effect to of any lawful conduct, and that certainly is not the state of our law. Insofar as the equality challenge is concerned, neither Rule 2570 nor the step-aside resolution constitutes discrimination in the sense that there was an irrational differentiation made between different categories of persons. In particular, we conclude that the categories of persons who fall to be dealt with by the NEC resolutions is both rational and properly justified, and we deal with that later in this note and deal with it more fully in the judgment as well. And therefore, the challenge located as it is in Section 9 and Section 10 of the Bill of Rights must also fail. The next contention is the attack launched on the step-aside rule. The issue raised by Mr. Magashule concerns the validity of the NEC resolutions. His case is that the NEC resolutions narrow down the resolutions of the National Conference and are therefore ultra vires the powers of the NEC. In essence, the contention is that the NEC resolution amended the National Conference resolutions under circumstances when the NEC was not empowered to do so. From a reading of the National Conference resolutions, it is apparent that they were formulated as broad and general principles. They do not appear to have been intended to constitute a rule. What is clear from those principles is that they reflect the concern with the scourge of corruption within the ANC, and that the ANC had taken an unequivocal stance in dealing with corruption and sought to eradicate it. The National Conference adopted a principle, we conclude, but did not formulate the procedures or the guidelines. It left it to the NEC to give substance to the principles and implement it by the adoption of appropriate rules. The NEC then, in accordance with its own powers and in accordance with the constitution of the ANC, adopted the guidelines in February 2021, and we have dealt with this earlier. There is, in our view, no merit in the contention that there was a narrowing down or a repurposing of the ANC conference resolutions by the NEC, and the challenge to the step-aside rule on this leg must also fail. We then proceed to deal with Mr. Magashule's suspension. And in challenging his suspension, he relies on two broad grounds. The first that the principles of natural justice, and in particular the Audi Alteram principle, was not applied. And then secondly, his challenge to the authority of the Deputy Secretary General to effect his suspension. We first deal with the question of Audi. The question of a hearing in the context of a suspension would entail whether Mr. Magashule was given information underlying the reasons for the proposed suspension and whether he was afforded an opportunity to make representations as to why he should not be suspended. The answer as to whether he was afforded a hearing before the suspension has to be found in the nature of Audi as an aspect of natural justice. In its application, it is a flexible rule that does not require rigid and formalistic procedures. In considering the facts and circumstances of this case, it is clear that Mr. Magashule was indeed afforded a hearing before he was suspended. He participated in all the processes relating to the development, formulation, and adoption of the resolutions of the National Conference regarding this matter, including the resolutions of the NEC that resulted in the formulation of the guidelines on the implementation of the step-aside principle. Furthermore, he was afforded ample opportunity at various levels of the process leading to his suspension to make representations as to why he should not be suspended. In particular, he had the fullest opportunity and did in fact state his case when he appeared before the Integrity Commission, as well as in other meetings of the NEC and in other meetings of the leadership of the ANC. On this score, we therefore conclude that the principles of natural justice, including Audi Alteram, were observed prior to his suspension. On the second leg of the challenge, the grounds upon which Mr. Magashule challenges his suspension is non-compliance with Rule 25.70 and non-compliance with Rule 16.9 of the ANC Constitution. In our view, and again for the reasons given, we do not believe that these contentions have any merit. Mr. Magashule's suspension must be understood within the context where the NEC at its meeting of 26th to the 29th of March resolved that all its members who had been charged with corruption or other serious crimes must step aside within 30 days, failing which they would be suspended in terms of Rule 25.70. It is not in dispute that Mr. Magashule was one of the members who had been charged with corruption. He was accordingly one of the members who was expected to step aside or face suspension. The contention by him that his suspension was unlawful for lack of compliance with the requirements of Rule 25.70 has no merit and stands to be rejected. And then on the question of the authority of the Deputy Secretary General, it is clear on the facts of this case that neither the NEC nor the National Working Committee could issue an instruction that Mr. Magashule should suspend himself. This would have placed him in a situation of a conflict of interest. The discretion to delegate the power and authority to issue the letter of suspension rested with the NEC, and accordingly, the DSG had the authority and power to issue Mr. Magashule with his letter of suspension. The suspension of Mr. Magashule cannot also then be set aside on this ground. Then the letter of suspension directed to Mr. Ramaphosa, and we deal with that briefly. Mr. Magashule in this regard seeks a declarator that the letter of suspension and the suspension of the president, as he contends, remains valid until it is set aside. In this regard, we simply point out that it is Mr. Magashule who seeks a declarator of validity in respect of Mr. Ramaphosa's suspension, and the court is obliged to inquire into the lawfulness of the action in question, in respect of which the declarator is sought. To that extent, there is no substance in the view advanced by Mr. Magashule that in the absence of a challenge by Mr. Ramaphosa to his suspension, the court is obliged to grant the declarator. If that was so, the court would be compelled to grant a declarator in respect of conduct that is not lawful and not administrative action as set out in the Oudekraal decision. This proposition is certainly not sustainable. What Rule 2570 requires in order for it to be triggered is that the person to be suspended must have been charged. It is clear, and it is common cause in the context of this matter, that Mr. Ramaphosa has not been charged in respect of any criminal offence, and therefore simple logic would conclude that it is not open to the ANC or to anybody to use Rule 2570 in circumstances where the individual in question has not been charged. That disposes of the question around the purported suspension of Mr. Ramaphosa, and the last issue is that of the withdrawal and the apology. Having found that the purported suspension of Mr. Ramaphosa was in conflict with the ANC's constitution, there is no basis to grant relief, setting aside the request to withdraw and apologize. We are not called upon to determine the appropriateness of any action the ANC may wish to take arising from this, and do not do so. And that brings us to the conclusion. In concluding, we have interrogated Mr. Magashule's claim to the relief he seeks against both the largely undisputed facts as well as the applicable legal framework to which reference has been made. Reverting to the three imperatives that we set out in the introduction to this judgment, it is clear that the recognition by the ANC of the nature and the extent of corruption and its impact on society and on the ANC triggered the need for decisive action by the party. On this score, there appears to be no dispute between the parties, and the call for decisive action in any event resonates with the objectives of the ANC as set out in its constitution, in particular, the commitment to social justice and the elimination of inequality. Secondly, the important associational and participation rights found in Section 18 and 19 of the Bill of Rights creates the necessary space for the ANC to bring together its leadership and members in the pursuit of a common vision and common objectives. In doing so, the ANC, through its constitution, created the model and mechanisms best suited to its structure and needs. Provided that such a model, evidenced by the ANC's constitution, is consistent with the Constitution of South Africa, and further provided that the ANC is loyal to its own constitution, it is largely left to the ANC to best regulate its internal functioning. This is what all members of the ANC sign on to when they elect to be part of the ANC, and this is the glue, as it were, that binds them together. It is a choice the court must respect within the limits we have described, but it is also a choice that has consequences for each member in the context of their associational rights. Finally, we are satisfied for the reasons that we have given, that the ANC constitution is consistent with that of the country, and that the decision to suspend Mr. Magashule was A, effected in terms of the ANC constitution, B, was precautionary in nature, C, complied with the law relevant to precautionary suspensions. However, in fairness to Mr. Magashule, we have also satisfied ourselves that his suspension accorded with the principles of natural justice, in the event that we may have erred in characterizing his suspension as precautionary. In finding that there was no basis to confirm the purported suspension of Mr. Ramaphosa, we pointed out that the mandatory requirements to effect such a suspension in terms of Rule 25.70, amongst them that he be indicted, were absent, and that there could therefore be no basis to activate Rule 25.70, as Mr. Magashule purported to do in support of his decision to suspend Mr. Ramaphosa. In all the circumstances, we would make the following order. 1. The application to strike out is dismissed with costs, including cost of 3 counsel, which costs are to exclude the cost of the duplicated documents as set out more fully in Annexures A and B to the notice in terms of Rule 6, brackets 15. 2, the application for condonation by Mr. Ramaphosa in respect of the late filing of his answering affidavit is granted. 3, the application incorporating the relief sought in paragraphs 2.1 to 2.3 of the notice of motion is dismissed with cost, including the cost of 3 counsel.
I agree.
The judgment is handed down.
As the court pleases.
As the court pleases.
Good, thank you. That concludes the proceedings. The court will adjourn and the judgment will be available on the Case Lines platform. Thank you.